All right, good afternoon, everyone. Thank you for coming out. Today's event, my name is Daniel Castro. I'm Vice President of the Information Technology and Innovation Foundation. Today's event is titled Why Policymakers Should Protect Public Speech Online. And our goal with this event is to discuss the problem of SLAPs, strategic lawsuits against public participation, and the role that anti-SLAP legislation has in protecting public discourse and civic participation, while also not deterring parties from filing legitimate lawsuits. This is a very serious issue that has important implications not only for free speech, but also for commerce. ITIF does a lot on the digital economy, and we of course come at this issue looking at the importance of protecting speech online for e-commerce to flourish. These types of lawsuits really undercut the enormous value offered by sites like Yelp or TripAdvisor by discouraging consumers from leaving honest feedback. And so we have a really fantastic set of panelists here today who I've asked to come here and kind of provide an introduction to this topic, provide an overview of what we've seen going on at the states, provide an overview of the state legislation that we've seen in this area, what's worked and what hasn't worked, why we're talking about federal legislation right now, and what we need to do to kind of move forward on these issues. We're going to be joined later today by Representative Farenthold, so I'll wait and introduce him when he gets here. He's obviously introduced the Speak Free Act, which has, which is federal legislation to address many of these topics that we've been talking about today. Let me start by introducing our panel. I'll start up here on my left. Ron Crenshaw is head of federal public policy for Yelp. He joined Yelp after a long tenure working in Representative Ice's office on IP and internet issues, and he's been very familiar with these issues for quite a while now. Continuing down the line, Mike Godwin is Director of Innovation Policy and General Counsel of the R Street Institute, where he leads the research and advocacy efforts on tech policy, freedom of expression, and a number of other issues. Down the line, Kevin Goldberg is a member at Fletcher Hildred, where he focuses on First Amendment and IP issues. Obviously been very involved in this, especially on the press side. Michael Hayes is the Government Affairs Manager for the Consumer Technology Association. He has deep expertise on many issues affecting the innovation economy, and at the far end is Evan County as the Policy Director of the Public Participation Project, which is a nonprofit organization that's been working closely on anti-SLAP issues, and previously he was an attorney with the California Anti-SLAP Project, so you have great expertise at the state level and now at the federal level. So first, thanks to all of you for being here today. Looking forward to this conversation. So let's just start off, and maybe Evan, maybe start with you. I just want to begin by just, let's just talk again about what exactly are we talking about here with SLAPs. What are these suits? Could you kind of describe what types of suits that you're seeing, not only you saw in California, but now that you're seeing kind of all over the country, and why do they matter so much to so many different people?
Yeah, so a SLAP essentially is a strategic lawsuit against public participation. When I started practicing as an attorney dealing with SLAPs about 6 years ago, we saw a lot of petition activity, speech happening, people speaking out in public about issues and being sued for statements that they had made. Over the past 6 years, we've really seen this shift with the rise of internet speech and sites like Yelp and TripAdvisor, and people are being sued for giving their opinions online. And essentially a SLAP is an attempt by a bully to silence a critic into submission and either taking back what they said, or in the case of like Yelp, deleting a review that they made. But the attempt is essentially to drown the defendant in legal fees and exhaust them mentally and make them take on a lot of time and resources defending against a meritless lawsuit. Essentially, is what it is.
Great. And maybe you can give a couple more examples of the types of lawsuits you see. Maybe a couple of the specifics. There's been some really kind of interesting ones, and actually I'll open it up to the whole panel because I know all of you know this. But we've just seen so many, from the Washington Redskins and their to on journalists to going after reviewers on websites. I'd like us to walk through a few of these cases to really kind of paint the picture of what we're seeing happen. So maybe a couple of you want to take some of the cases that you're most familiar with.
You've got a good one to start, I know that.
All right, you can jump in on this one. Essentially, maybe familiar to all of you, Dan Snyder, the owner of the Washington Redskins. All right.
You got to do a different one. That was mine. That's my client.
Take it. He can take it. Take that one.
I don't, well, okay, so you all, are anyone in this room familiar with this? You know, I mean, here's the nut graph, so to speak. So as Daniel said, I'm an attorney in private practice, but two of my biggest clients are the American Society of News Editors and the Association of Alternative News Weeklies. So in this town, I got both the Post and the City Paper as my members. And the City Paper wrote something called A Cranky Fan's Guide to Daniel, A to Z Guide to Daniel Snyder. And then they received a letter from Snyder's attorney, which had this nut graph to it. Mr. Snyder has more than sufficient means to protect his reputation and defend himself and his wife against your paper's concerted effort at character assassination. We presume that defending such litigation would not be a rational strategy for an investment fund such as yours. Indeed, the cost of litigation would presumably quickly outstrip the asset value of the Washington City Paper. In other words, Daniel Snyder wasn't even talking to the City Paper, he was talking to the owners of the City Paper, trying to get them to tell the City Paper to self-censor or issue a correction or an apology. And he did simply under one theory of law. I'm richer than you, and I will get what I want. That's it. And he did this even better. He sued the Washington City Paper in New York because New York did not have a very strong anti-SLAPP law. And then the case was moved back to DC, at which point, because DC does have a very good anti-SLAPP law, he withdrew his lawsuit. That to me, I mean, I stopped being a fan of the football team. I grew up here. I stopped being a fan of the football team when he took ownership. I like to say I was an early adopter.
Ahead of the curve.
Yes. This sealed the deal. I mean, that's it. We were done. Sorry.
No, that's a good one. And there's plenty of other high-profile ones like that. Rachel Maddow was slapped. Oprah was slapped for saying she'd never eat another hamburger again by the beef industry in Texas. For an organization, and for me, I'm more interested in, not more interested, but the ones that don't get the attention, the ones that aren't on the front page of the media. When an individual from Kentucky, for example, reaches out to me because they gave their opinion online about a certain business or something, and now they've been sued for defamation with something like hundreds of thousands of dollars, requesting millions of dollars in damages. And because they're in Kentucky, and Kentucky has no anti-SLAPP law, what are they forced to do? They're either forced to just take down that review, or they're going to fight it, and by fighting it, they're going to have to pay an attorney. There's going to be a lot of exhausting time and resources spent on this case. And then at the end, sure, the case might get dismissed, but what do they have to show for that? And that's why I think we're here today, essentially, because federal anti-SLAPP legislation is something very important that would protect someone like that person in a state that doesn't have any anti-SLAPP laws.
And I think that it's important to note, right, this isn't about individual one-off cases per se. And you look at an online ecosystem like Yelp or TripAdvisor that relies on honest user-generated content, and we can't rely on individuals from California and Texas and Oregon that happen to have good anti-SLAPP laws to be confident in posting real online reviews of places that truly do have negative things to be reported on. If any of you use Yelp and happen to live in Virginia, you don't necessarily have those same luxuries. And there have been cases where individuals, for posting honest content about what they experienced at a business, have been sued by that business to take down that content. And that's frightening for the individual, but it's really damaging for the online ecosystem when a Yelp user goes online in Virginia, and they might not necessarily be getting content that's actually reflective of that business.
I know that we both have a lot to share, so
Absolutely.
maybe Laurent, I know that you know a lot about gathering information about what we know about these cases and how below the radar some of them are.
Absolutely, and I think just to jump off of what Mike said just now, there's a reason that we're here right now talking about anti-SLAPP legislation and how public officials can protect speech online. Anti-SLAPP laws and the anti-SLAPP law in California is not new. It's been around for over 20 years. A lot of the other anti-SLAPP laws have been around for a significant period of time as well. It's just that we are in a place now as more and more people choose to share their opinion on the internet, and as their sort of online reputation continues to become more and more important to, especially for a business, to sort of their standing. And I'll throw the fact out there that approximately almost 70%, 69% of people use the internet and online reviews in particular before they make a purchasing decision. It's probably most of the people in this room, most of the people watching the video as well, sort of nod their heads and say, yeah, I do that as well. And as that ecosystem, this whole feedback economy is really continuing drive. With that, you have individuals who, rather than trying to engage and actually provide great customer service, or sort of saying, you know what, while I don't agree with what you said, I'm going to respect your opinion, rather than say, I don't like what you said and I'm going to sue you to take it down. We're now in this situation where there are bullies, basically, who are trying to use their power to intimidate others. And Yelp as a platform, as Michael Hayes mentioned earlier, is one where, you know, occasionally we have users who are targeted by those types of actors. Another stat that I'll give you is that, you know, we've looked on our back end and found that approximately 1 in every 20,000 or so reviews that are placed on Yelp reviewers end up being threatened with some sort of a slap. Now, that might not mean that it actually goes to court, and in most instances where we're talking about slaps, the goal isn't to necessarily have that lengthy, drawn-out process of trying to determine whether or not there's actual defamation. It's just to intimidate the person who wrote that honest statement in the first place and then taking it off of the internet. And so when I say that 1 in every 20,000 reviews, I also want to put it in the context of the 100 million reviews that are on Yelp currently. And that's just on Yelp. That's not counting TripAdvisor, which is a company that's similar to ours, which has also seen thousands of these instances of people being threatened with some form of a punishment because they wrote a statement that that business didn't agree with. I'll stop there.
Yeah, let me jump in here, because I actually, I was an early adopter of bulletin board systems. Even before the public internet, I was participating in online systems when I was a law student in Austin, Texas in the 1980s. It's actually how I know Representative Farenthold. We first met more than 30 years ago on BBSs in Texas. We never thought we would end up here, so that happened.
But his username?
No, you can't. No, I will. There's Blake. He was Blake. He was always Blake in the BBSs of the time. But the thing was, I was a law student, and I was really interested in kind of constitutional law in the abstract. And then I was on BBS, and I posted something critical of a computer consultancy in Austin. And the first thing they did was show up and say, since you're a law student, Mike Godwin, we know that you know what libel law is, and they wanted to threaten me for actually having said something critical about their business. But I wasn't doing it as a competitor. I wasn't doing it maliciously. I was actually sharing my own assessment of the advice that they've given or a project that they worked on. And my first thought was not, oh my goodness, I'm being sued, because I had no money. I was a student. I wasn't terribly worried about having less than no money. You know, that was okay. But what I thought was, oh wait, this thing that's happening online really involves freedom of expression, and people historically have used libel laws to suppress critical points of view. They've used libel laws, which are supposed to protect reputation, actually to shut down public discussion that we think in an open society we ought to allow. So I want to add just maybe one other point into the mix here, and that's that you may ask yourself, what is Congress doing regarding, in terms of if we do move forward with the Speak Free Act or something similar, what is Congress doing in terms of intervening in the state law legal regimes? And I think it's pretty straightforward. Because Congress is well within the scope of Congress to protect First Amendment rights by statute. So apart from whatever the courts do, Congress can do and has passed laws, the purpose of which is to protect freedom of the press. And the example, one law that I got to actually use in one of the early online freedom cases is the Privacy Protection Act of 1980. The Supreme Court had decided that newsroom searches of newspaper newsrooms were maybe okay under the Fourth Amendment, but Congress said, no way, we do not want police agencies shutting down newsrooms to search through reporters' notes. We think the baseline of protection ought to be higher than that under the First Amendment. So Congress passed the Privacy Protection Act of 1980, and we were successful when I was working with the Electronic Frontier Foundation way back when in 1990 to 99. But we were able to win a case with the Privacy Protection Act that was based on Congress's deciding that they needed to protect First Amendment rights more than the courts did. And Congress does get to do that.
Did you want to add anything on that?
Well, I don't, you may get down to this later on. I mean, the idea of sort of, I think fundamentally we all understand why this is important, right? There are different reasons. I mean, there are everything from preserving the validity of looking at a site like Yelp or TripAdvisor and seeing reviews, and then there's the impact that it may have on you. I mean, who here has not said something stupid in some way at some point? And that kind of brings us to why we're here now, because in the past you would have said something stupid and there would have been no outlet for people to hear you. Now you have things like Yelp, TripAdvisor, Twitter, you know, where you're just, I mean, again, raise your hand if you have never said something stupid on Twitter that you later regretted, that maybe about an airline or something where you were just angry. I'm laughing because I saw a tweet from Laura the other day about...
It didn't feel stupid at the time.
but you know, I kind of came, he's like, I'm trying to decide what to say. And I'm like, no, don't worry, you're in Nevada. They got a pretty good anti-slap law. Go for it, man. You know, and that could be any one of us. That could absolutely be any one of us. But why does Congress need to step in? And you've heard, I think, both sides of it. There are a number of states that don't have any protection or have very weak protection. And we need to fill in that gap. And now we're seeing on a procedural level that some federal courts have said that the state laws that do exist may not be applicable in federal court. So it's sort of a dual attack as to why we need this. You know, I don't want to get too technically ahead of ourselves in terms of debating law or explaining law, but really what it is that if this is a procedural rule only that governs when a case is allowed to be filed or dismissed, or you know, allowed to be dismissed, then maybe you cannot apply it in a state law, a state court case. And similarly, you can't apply a state case in federal court. If it's a substantive law under the First Amendment, then we really Congress could step in and write this law. We cover a lot of these gaps all at once. But that's why we have to have this, you know, in any number of senses, from the legal to the simply policy right now.
Yeah, so I want to take a step back for a minute. And, I mean, you know, I think everyone on this panel has done a really good job of kind of illustrating why, you know, on the consumer level, you know, especially, you know, starting there, it's so important. I mean, we had the internet as this kind of great equalizer, where suddenly people had their voices able to be heard, or we were able to, you know, have this kind of crowdsourced wisdom. And, you know, the kind of growing trend, or what appears to be at least a growing trend, of, you know, abusive uses of different laws to silence people's voices online really threatens that model that we built up of how, you know, how important the internet is. But there's also, you know, these other components. I want to talk about, we touched on the journalism side. I want to dig into that a little bit more. And I also want to talk about, you know, its relevance for corporate speech, because there's also a, you know, there's a side of that too. So let's start with that, and then just to give everyone kind of a roadmap of what we're going to be doing here. I want to, after we kind of talk a little bit more about the types of you know, lawsuits that we're seeing against different entities, then we're going to dig a little bit more into what states have been doing. And so, you know, Kevin was just talking about, you know, the kind of remedies available. I want us to kind of walk through exactly, you know, what this process looks like for individuals that are facing these lawsuits, and how anti-SLAPP legislation actually, you know, helps find a way out of this to kind of, you know, reset that balance. So why don't we start again? Let's do a little bit more on the journalism. I think this is something that, you know, is, you know, as you said, there's lots of different reasons. It's really interesting in this law. There's actually many different reasons why we want this. And, you know, so we talked about consumers. Let's talk a little bit more about the journalism side. Obviously, there's one case that's very hot right now. I don't know if anyone wants to talk about that one in terms of, you know, someone that was threatened recently by a very prominent presidential candidate. So we can get into that. Or I know there's been others, so I'll just open this up. Kevin, maybe you want to start.
I have a good one from last year. It doesn't involve a presidential candidate, but it does involve a politician. And it was the mayor of Sacramento, Kevin Johnson, who was also a former NBA basketball player, very popular guy, and pretty wealthy. And there was a dispute in his about whether he was using his official position too broadly with regard to another position he had in leadership of the National Conference of Black Mayors. And so whether he was leveraging his political power in ways he shouldn't have. And so the Sacramento News and Review, the local alt weekly, again, sort of the equivalent of the city paper, filed a FOIA request seeking official emails to and from his office on this topic. And he basically threatened them with a lawsuit, and later did file a lawsuit simply because they refused to withdraw their public records request. I mean, that's, you know, whether he was engaged in, they were just trying to find out whether he was engaged effectively in a misappropriation of public funds. And he sued them to withdraw a public records request. That to me was one of the more egregious I've seen in the last 2 years. And, you know, and this isn't a corporate entity. This is, like I said, it's an alt-weekly. Not, you know, they're no better built to withstand this than any other small business. But they're doing a public service and getting sued for it.
Yeah, I'll hop in here, just because you mentioned Trump.
I didn't mention
You didn't mention him. You don't want to be slapped by him. Because he does have a long history of suing individuals, critics, and also threatening lawsuits. And just a few to note that are interesting to point out. He dragged reporter Tim O'Brien, 3 years of litigation. O'Brien wrote a relatively favorable biography of Trump, but Trump was upset that he put his net worth lower than what Trump thought it should be at, amongst other things. He sued the Chicago Tribune's architecture critic for, quote, he was talking about a skyscraper Trump was planning in Manhattan. He said, quote, it would be one of the silliest things, unquote, that could be built in the city. He sued for that. He's used the threat of litigation numerous times. You know, he actually even sued Bill Maher in California over a joke that Bill Maher had made on his show. So, I mean, I think that's just, when you're talking about media and journalism, he is a great example of someone who has used slaps and threat of slaps as a tactic to shut up his critics or silence them or just drag them in legal fees. And he's outright said, you know, I mean, there's some quotes, you know, about the financial resources he has to do these and not worry about the ramifications.
Let me add a little bit about, just on the journalism theme, and that's that we used to, you know, the world I grew up in was one in which journalists were a profession. They, you know, they were a separate entity, you know, and I knew people who were reporters or editors, but maybe I wasn't one. But that world is not the world that the internet has created for all of us. The internet has created ways for all of us to choose to function as journalists, to report on what we see, to use our phones and take pictures of things that we see and share them with the world. And we have an opportunity to share information, to participate as journalists, to participate in the public dialogue. And this, to me, is a personal right that the First Amendment guarantees. So as you know, the First Amendment guarantees freedom of speech and also of the press. But what you now see is that the First Amendment has united under the internet, where speech and press really have the same degree of protection. So the casual comments, or the comments that you mean quite earnestly, that you've researched when you critically review a business or when you critically review a restaurant, these are things that you have a right personally to engage in, and it's really important for Congress to continue, as it has done in the past, to recognize that this is an individual right and that it needs protection.
And just to echo off of that a little bit more, because while Kevin a little while ago was sort of talking about the stupid things that you can tweet out, you know, or that you might be encouraged to, and that's okay. Moving away from that, though, when you look at, you know, whether it's online reviews or whether it's a blog post that you make, or whether you are an independent journalist going beyond that who uses the internet as your medium for publishing, or even statements that are made on Medium, when you look at that, a lot of those instances, certainly it can just be, you know, a casual conversation, or even what you're saying on Twitter, but oftentimes there could be useful information that you're providing to the public contained within that statement that you make. And there's a reason that, in particular, that you use the internet as a forum to make that statement, whether it's Yelp, whether it's Facebook, or whether it's TripAdvisor or anything else, but it's because within that conversation that you're having with the public, there are facts and figures and things that can be aggregated from that, and so that, you know, whether it's a review for a place that's around you, and, you know, let's say Mike writes a review and later on I see it and I say, oh wow, I was going to go there, except according to Mike, that place has an issue with rodents. Now I know not to go there. That's an incredibly useful piece of information that I might not learn otherwise if he hadn't taken the time to provide sort of that, you know, that warning, which, you know, in the past, it might have been, I love sort of the Oregon Trail analogy of sort of the signposts that people would say, you know, posts that would say like, warning, this water is poison, don't drink it, otherwise you're going to have issues later. And in a lot of ways, the internet is just, you know, an incredibly complex evolution of that, especially when it comes to independent bloggers, news, and review sites.
I think an important piece of context too when you're thinking about Speak Free Act or why it's so important for Congress to be engaging on this issue, it's not necessarily to fix a specific individual problem of, you know, lawsuits over reviews or lawsuits over journalists. You know, one of the most important things for CTA is to create an environment in which you can have new companies thrive and new ideas thrive. You want an ecosystem that rewards creativity. And if people are afraid to participate in any sort of venue, whether it's a news venue, whether it's an online venue, that by its nature keeps people out of the creative economy and keeps them doing something safe. And so when you're doing this, you're solving some issues of making sure that individuals in news and individuals on Yelp and other places can post honest reviews, express honest opinions, but you're also creating a national environment where people aren't afraid to speak out on whatever new platform or whatever new way of engagement there might be in the future.
Well, in that sense, it's like the Communications Decency Act. I mean, you know, people have complaints about that. You know, maybe speech gets too caustic at one point or another, but I think looking back on the last 20 years, there's no doubt that the internet ecosystem grew as a result of Section 230. And I think this is kind of almost a natural, maybe a child of Section 230 in a way that's going to carry the internet to more and more individual free speech, but keep the platform strong.
And, you know, I think it's worth noting too that, you know, so much of this is about really clarifying the rules and empowering the consumers, because, you know, there's some of these, you know, lawsuits that eventually might be, you know, dismissed and, you know, it could be won. But the whole point is, you know, if you know, I as a consumer receive a lawsuit, I'm gonna just back down. I mean, it's just not worth it to fight it. You know, I can go onto my site and with a couple clicks just fix the issue, or I can hire a lawyer, you know, try and figure out how to do that, try and pay for this. And there's this, you know, I mean, when we were looking at it, I mean, so much of this is about, you know, this kind of, you know, if my friend, you know, gets sued, that's going to affect me too, right? Because I'm going to say, well, I would have said the exact same thing this guy said, and then I think twice about posting it. So it's not only kind of the direct impact, it's this huge kind of ripple effect that is so important.
And you can take it out earlier. You know, I'm sure Evan's had the same issues because you had the same considerations, but I know I've had clients and they get threatened with something, or even before they get threatened, it's in the back of your head. I mean, a lot of what I do is pre-publication or pre-broadcast review for clients. And they'll come to me and say, what do you think about this? And it's always a factor in the back of your mind. Do you have an if push comes to shove, do you have an anti-SLAPP law to back you up? And that is really in the consideration between, in my instance, between journalist and lawyer. And they're asking me, boy, how far do I want to go with this? You know, I'm a little worried. You know I have the facts, but I'm worried about getting sued because this person, they're the type that is going to sue to protect themselves because they know their reputation is going to drop, even though everything I'm printing is true. You know, you do take this into your consideration right from the start before you even publish, and that's self-censorship. You know, if you gotta withhold what you're going to say.
I want to add a little bit to that, and that's that, you know, the Speak Free Act and any similar measure that is designed to make these cases easier to resolve quickly and in favor of freedom of expression is not just a kind of a formal thing. It also is a chance for Congress to speak and say that we in Congress believe that you should feel free to speak freely on the internet and to have and to post reviews and share your opinions and to engage, so that even if that environment and expectation is created, then businesses or individuals will be less inclined to send even a threatening letter because the backdrop of a possible expensive lawsuit is much more in the distance. So it creates a shared understanding that what we do on the internet, we are empowered to share our opinion, and really only if we engage in truly malicious falsehood, or only if we engage in unfair and particularly unbound by fact speech, should we even have to consider whether that's going to happen? This is a chance for Congress to actually set expectations that apply to people who will never be defendants or never be potential defendants, because they'll know that they can speak more freely. Congress is standing up for that.
Yeah, I think just to be clear here, like, no one on this panel is going to say or in any way is endorsing anything that involves like making it easier to defame someone. Defamation is a pretty clear standard already, as is, and you know that's the standard that the Speak Free Act and anti-SLAPP legislation in general doesn't mess with. It's not going that far. It's talking about, does the threat that's been, does the question, you know, does the sort of the speech that's at question here even meet the threshold that we should actually look and explore if it's really defamatory or not? And I think that that's a really key distinction, because some people, when they hear about the issue, just sort of say, oh, well, you're just trying to make it easier for people to say crazy things on the internet and not get sued. So no, we're trying to make it so that you don't have bullies, whether they're running for a presidential office or otherwise, or a corporate entity that can just use their money and their resources to intimidate another parties to get them to remove their speech from either the internet or from print or from any format.
And I wanted us to talk about you know, corporations as well. Obviously, it's businesses and business owners that are also getting sued. I'm wondering if Mike or Michael, if either of you want to talk about the Zenefits case versus ADP or any of these other kind of larger corporate cases we're seeing.
So I don't want to talk about Zenefits in particular, but I really sort of want us to speak generally about the fact that competitors, we actually want competitive businesses in the marketplace to be able to say truthful things about what they offer or what they think their advantage is over another competitor. We want them to be able to do that. And we would like, ideally, the disagreements about whether one service is better than another service to be resolved, you know, by more public debate. The best answer for bad speech is good speech, and the best way to get good speech is normally to allow more speech. So we really want to support the fact that corporations and competitors and small businesses and large businesses also have a stake in this.
And I think that if you look at the corporate side of this, you know, it's a macro version of what happens on the individual side of this. It's whoever has more money has the upper hand and gets to silence the person that has less money and less time to waste in court. So yes, it's still important, but it's essentially the same issue, that you have someone who's using their market power or financial power to silence someone else who is a little bit less powerful than them and happens to be inconvenient to whatever they're doing. And that's just inherently unfair, right? This is an opportunity for Congress to step in, make sure that everyone's able to speak on a legal playing field without fear of any sort of repercussion.
And sometimes it's not even about who has more money, but who sues first and puts the other one on the back foot. You know, and that's unfortunate as well, that we're creating an incentive without this law, or have created an incentive for people to go to court really quickly to protect their rights, when, as you said, the answer is not to go to court. The law is intended to promote more speech on both sides.
So let's dig in a little bit on what the states have been doing with anti-SLAPP legislation and how that kind of starts feeding into what we're talking about today, federal legislation. So Evan, why don't we, you know, it'd probably be good for you to kind of kick off this discussion and talk about, you know, kind of what states originally did, what you were doing in California, and now how, you know, what the landscape looks like now.
Yeah, it's one of the reasons I've actually been always really attracted to this issue, is that the First Amendment isn't partisan. All Americans respect and value the First Amendment. And I think that's why you've seen states like California, who has one of the strongest anti-SLAPP laws on the books for over 20 years. And then you have a state like Texas, which more recently has enacted a very strong anti-SLAPP law of its own that was passed unanimously and ended up being signed by Governor Perry. So I think we're seeing more and more states enact anti-SLAPP laws. The issue is that we still have almost half the states without anti-SLAPP laws. And those states that do, some of them vary in strength and breadth. So New York, for example, has a very weak anti-SLAPP law. And what this does is it sort of creates two loopholes. One is that plaintiffs can forum shop and look to file their SLAPP in a jurisdiction where there is no anti-SLAPP law or where it's very weak, Or lawyers have gotten a little more creative and they will look to plead around a state anti-SLAPP law by filing a federal claim in a federal court, which isn't subject to a state anti-SLAPP law. So I think those two issues really sort of highlight the need for the Speak Free Act and this federal anti-SLAPP law to close up those two loopholes and give Americans across the country uniform protections against SLAPPs.
I think also you look at states that do have successful anti-SLAPP laws, Oregon, Texas, California, and others. There hasn't been a rash of people defaming businesses. There hasn't been any negative consequence of average people or even other business competitors abusing these statutes. I think you'd be very hard-pressed to find any instance at all where they were used incorrectly. On the contrary, they have encouraged a more open, robust dialogue in those states.
Laurent, did you want to talk about this? Because I know you've also seen this kind of play out just in terms of Yelp customers. You kind of see that there are some that have protections and some that don't. Can you talk a little bit about that?
Sure. I mean, we just actually recently, there was the Nevada case, I think, that actually, Kevin, if you have the details on that, maybe you want to sort of explain it a little bit more.
I printed it out this week.
That's why I
got it right in front of me. It's a case called IQ Tax versus Bowling, where a woman had hired a tax filing company to, do some filings for her. Timely, I guess, right now, isn't it? You just got the taxes done, right? And she then felt that things hadn't been done the right way. And in one instance, what happened was she was hit with a penalty, and she actually asked for an economic hardship filing to be made on her behalf, and it was unclear whether it was done. And so she really, at some point she got to the end of her rope, and she wrote a review on Yelp, and that had some accurate factual statements, some opinions, and then at the end said, this is malpractice. And let me tell you, the libel law is clear on this. Factual statements, as long as it's clear that you have facts and then you have opinions, that's fine. That is not, if it's clear that this is malpractice, was really her statement of opinion, especially because she was not a lawyer, she was not an accountant, and she presented all the clarifying underlying facts to allow someone to agree or disagree with her conclusion that this is malpractice, would not in and of itself be libelous. I've seen this in a number of cases over the last year even, that oddly this issue keeps coming up. And the tax company sent her a cease and desist. She then actually, and in the letter to her, described the Yelp review as an exaggerated emotional rant review on the IQ Tax Yelp page. They told her to take it down. She actually did, and she posted another version without the word, this is malpractice. She still got sued. She got sued for, let's see, intentional interference with contract or prospective economic advantage, libel, and libel per se. And she, in the Nevada courts, filed it, defended herself, in part through the filing of a special motion of the Nevada anti-SLAPP, and she won. And she actually got some attorney's fees as well. And I think, this was a case in which, as we talked about earlier, the decision shows that courts sort of don't take any part of this lightly. They are very clearly going through all of the components, looking at both sides of the case instead of just seeing an anti-SLAPP and then kicking it out. They're devoting a lot of time to the substance of the complaint, but clearly recognized that it was a frivolous lawsuit and acted accordingly.
And so, to bring it back a little bit more to the Yelp perspective here, that user hadn't been in Nevada, but had been in Georgia, Virginia, or numerous other states of the 22 they don't have an anti-SLAPP law in books, she would have been basically SOL.
Yeah.
And so why we certainly have supported anti-SLAPP laws and at the state level, and feel that obviously that states have the right and the ability to do that, and we thoroughly advocated for the strengthening of state-based laws in places where, like New York, where they are unfortunately on the weaker side, and will continue to. But at the same time, we do think that this is an area that really is in need of basically Congress to set the standard. To set a standard that is appropriate and can be accessed by all Americans regardless of where they live. And we think that there are, obviously we support the Speak Free Act, but there are also, there are multiple ways to really look at this issue of how to protect people's statements that they make online.
So I want to make sure that we provide enough details so for those in the room that are hearing there's weak and there's strong laws, that we give a little more color to what that actually looks like. So I'll open this up to whoever wants to take it, but I think it'd be useful to kind of walk through a little bit about what we actually see in these statutes. I mean, how exactly does someone use an anti-SLAPP law? And when the state legislators are looking at this, what are the building blocks, what are the pieces that they're using here in terms of things like fee recovery or the kind of speed at which you go through these processes? And why don't we walk through a little bit of that so we can provide that detail?
Now you.
I'll go a little bit. I mean, I think one of the most important components that you'll see in any anti-SLAPP law is the attorney fees provision, right? So, if, for example, you had an anti-SLAPP law with no attorney fees provision, in my opinion, you're just as bad off as someone in a state with no anti-SLAPP law, right? Because with the attorney fees provision, you can find an attorney to take the case on a contingency fee basis, potentially, which is how we represented a lot of clients in California who couldn't afford an attorney, but we saw that they were clearly being slapped. And so we would take on that case knowing that we would be able to recover attorney's fees if we prevailed on the anti-SLAPP motion. So, I mean, for me, I think the attorney's fees is a really huge component of the anti-SLAPP law. You can get into more.
Well, I think fundamentally the way this works is, and in this Nevada case I just mentioned, IQ tax, which if any of you want to read it, it's from the Clark County District Court, and it was only issued like last week. It's not very long. That's the part I should have said first. It's only like 12 pages long. And it's really kind of explains the way a lot of these shake out in practice. So a lawsuit gets filed, and then there's a threshold for the defendant to determine whether they could invoke the anti-SLAPP. And around the country, so we start talking about stronger or weaker laws. Well, the first question is, when can you invoke the anti-SLAPP? Some states say, oh, it's only on a matter where you're petitioning the government. So you would have had to have made a statement in actual official filing. These are like the really narrow ones. Others are much broader, and we're going to see all these components in the Speak Free Act when we start talking about that. So the first question is sort of how would you define when the defendant's going to be able to even sort of raise an anti-SLAPP motion to dismiss? And some may be much broader. They may say any statement on a matter of public concern. And they may define matter of public concern. And they may have different levels as to whether you have to show that by preponderance of the evidence or by clear and convincing evidence that this is a matter of public concern. And when you do that, usually what happens then is it switches to the plaintiff to come back and show by some level of proof that maybe they were likely to prevail on the merits, or they have a substantial likelihood of prevailing on the merits. And again, you have different burdens of proof. But that's kind of how it works, and how they can vary in different ways is what do the details of the law say that each side has to show. And all of this happens under most anti-SLAPP laws in a very compact time frame. So the best ones are going to say, look, this has to be done all in the pleadings, no expensive discovery, no drawn-out process. And some, and others will say, well, there may be exceptions that allow the court to look for more evidence. And then, and as Evan said, the strongest of those not only compress the time frame and get you out of court quicker, saving both parties on legal fees, unburdening the court system, all these things, but some will actually give the winning defendant, which is unusual, to say the least, under U.S. law, the possibility of their own damages. Now, the best of the best laws will also add onto this the fact that if you're a defendant and you lose, you have an immediate right of appeal. So the case doesn't go to trial. You can actually then immediately appeal and continue to fight your fight without then losing any benefit to it. So there's a lot of different components in that sense that will make a law better or worse than others. Those are the main ones.
All you have to do really is put yourself in the position of an ordinary citizen defendant. What do you want? First of all, you want it not to be commonplace to be threatened with legal action. That's a baseline. But certainly if you are threatened with legal action, you would like there to be an understanding, shared understanding that this case probably doesn't have merit, so that you at least have some negotiating room. You'd like to have your legal fees met by the person who frivolously sued you, rather than by you putting a second mortgage on your house. You would like to have that happen. You would like it all to be resolved in a quick time frame. So, and if you by any chance should lose at some level, you'd like to have the appeals process be resolved very quickly as well. So whenever you think about this as a potential individual defendant, it helps put this in perspective. You want this wrapped up quickly, you don't want to eat a lot of costs, and you want there to be a general understanding that you do get to share your honest opinion, you do get to share the facts as you understand them with the public in any forum everywhere. And I want to point out, by the way, that the federal law that I mentioned earlier that, about the Privacy Protection Act of 1980, we actually represented someone who was not a newspaper. We represented someone who was running an online forum in 1990. And he was running a BBS, a computer bulletin board system, and we understood that he had the same rights as a publisher and a reporter as anyone else.
And so I think the kind of obvious question that people, especially that are kind of new to this, will have is, well, you know, this all sounds great. Why don't we just let the states deal with this? You know, why are we talking about it, you know, here in DC? So why don't we kind of move into, you know, what we're talking about with federal legislation, the value that it brings, and you know, how it addresses the kind of different gaps that we're seeing right now at the state level. So Ron, maybe you can start.
Sure. I mean, the sort of quick answer to your question from my perspective, and speaking on behalf of Yelp, is that you know, we're dealing with individuals who are making statements online, who are on the internet, and at certain times they are, you know, in different jurisdictions. So there's sort of like the whole like diversity issue there, where one person might be making a statement about a place that's in another state. And then also at the same time, you typically have plaintiffs, as Evan mentioned earlier, who will engage in forum shopping, who will look for the state that has the weakest or no anti-SLAPP law on the books that they can in order to actually file a complaint against you. And so that again empowers the business or the person who has the resources and the money to do that in order to try to intimidate you in your speech by basically, whereas, you know, you kind of have to deal with them in that jurisdiction, versus if we had a federal law, then there's at least a back-end degree of certainty, no matter where you are and where you're at, that you have access to an anti-SLAPP motion to protect yourself and to be on an equal playing field with the person who's bringing the suit against you.
Yeah, at a federal level, yeah, at a federal level, right, you have a certain amount of fundamental rights that are protected, and one of them is free speech. And that helps us be able to have all sorts of innovative companies, brand new ideas, things that you don't necessarily see in other countries. And when that is applied in a disparate manner throughout the states, and frankly, people then have uneven opportunities depending on where they happen to live at the time. That's something that we believe at the federal level should get some basic amount of protection. That way people are allowed to speak their mind no matter where they live. You know, I think that that's just a basic implementation of a fundamental right in the United States.
Great, thank you. Well, what we're going to do right now is we're going to pause the panel because we have a very special guest here joining us now. So let me, it's my pleasure to welcome Representative Blake Farenthold, who's currently serving his third term as representative from the 27th District of Texas. Last May, Representative Farenthold and Representative Anna Eshoo introduced this bipartisan Speak Free Act, which we've been discussing right now, which would enhance free speech protections for consumers on the internet and others by protecting them from frivolous lawsuits. As you've heard in this discussion, you know, states have made some progress on these issues, but it's clear that there's, you know, some kind of need for federal backstop legislation. So we're delighted that you're here today joining us. Please join me in welcoming Representative Farenthold.
Thanks. We were actually on the floor voting, which is why I was not here to begin with, and now the panel, I'm sure, has stolen all my thunder. But I did want to take an opportunity to get in front of you guys and let you know how important I think this is. We've got a situation that we've got business owners and others who are trying to stop people from telling the truth, and it's the classic case of the tort system in this country being abused. I have a law school professor, when I went to law school back when the Flintstones were still around, that once said you can beat the rat, but you can't beat the ride. And we've got folks that will take you for a ride if they don't like what you're posting on Yelp or TripAdvisor or you know, whatever website you want. And we need to have, in the digital age, folks have the opportunity to give their honest opinion and have a way out of it without having tens of thousands of dollars or more worth of attorney's fees. We've got to create a system where those people who do feel like they've been wronged or defamed have an opportunity to express their claim, but we don't want to make the system such that it's ripe for abuse. So regardless of how meritorious your claim is, you can just move forward and hold somebody hostage for the attorney's fees. I guarantee you there are not many people who either have the resources or the desire to spend their money defending this. It's just easier to take the post down, and that stifles free speech. And there's some critics who say, well, we've got states doing this, let's leave it to the states. And listen, I'm a conservative Republican. I believe we should leave as much to the states as we can. But the First Amendment is a federal creation. It's a creature of the federal system. And my oath of office to protect the Constitution, I think, includes protecting the First Amendment from plaintiffs' attorneys and folks who want to stifle your right to comment about things people are interested in, whether it's how good the burger is or what you think of your congressman. And believe me, I've thought about wanting to sue some people who said some stuff on Twitter about me, but I do respect their First Amendment rights, and that's why I'm doing this legislation. It's why I think I have the support of most of the folks on this panel, and would love to get this through this year, because this is something that is bipartisan nature. President Obama supports it, and I'm not sure the next president will. I think one of the candidates has 5 slap suits he's filed. So, anyway, encourage y'all to get behind this. Let's get it moving this year. Thanks. I'm getting a cookie.
Well, thank you again for joining us and for providing that update on your motivation for doing this. We were just talking right now about the role and the need for federal legislation in this area, and obviously Representative Farenthold has very clearly articulated both the need and the role the federal government has in this space. I want us to dig a little bit more into some of the provisions specifically in the federal bill, and how you see that helping the various individuals and businesses and journalists who are being affected by this. And so, Kevin, maybe I'll turn it back to you again. And looking specifically at some of the provisions in the legislation, obviously representing the clients, how do you see this actually helping you help your clients going forward?
Well, I think, I talked about some of the components of a good anti-SLAPP law, and there's no doubt that the Speak Free Act has many of the strongest components. It does apply to any oral or written statement or expression by a defendant that was made in connection with an official proceeding or about as a matter of public concern, and then there's a very broad definition of matters of public concern. And so I think it makes it very, there's a lot of protection for, again, a journalist who's speaking out on something or writing about something, or an individual who's writing about something, to say, I was speaking out on a matter of public concern. And it could be anything from that burger to that congressman. And they're all matters of public concern to somebody, right? Again, the tax case I just talked about from Nevada, the anti-SLAPP case. Clearly a matter of public concern. One person making a statement about a company that she felt had wronged her, and letting other people know why or why not they might find themselves being penalized, punished, whatever, threatened with action from the IRS, a government agency. All right? Not an official proceeding, but certainly a matter of public concern. And I think so that is something that from the outset makes it very favorable and very necessary. And then the law, talks about, it does have the provision that allows that, if the defendant successfully shows the lawsuit was made, was based on such a statement, the case is dismissed unless the plaintiff can show that the claim is likely to succeed on the merits. Not an insurmountable burden, but an appropriately high burden. And then, you have different time frames that I think are appropriately appropriately set to decide the case quickly, but without forcing a court to do anything less than a thorough review. So, for instance, the court has to hold a hearing on the motion side. It doesn't have to do all this on paper. It actually can have a hearing on the motion to dismiss under the anti-SLAPP within 30 days, though if it needs more time, it can extend that by a short period. And again, this does allow for what we call an interlocutory appeal. If I'm the defendant that loses, I get to go and appeal that decision right away. I still don't have to go to trial, and most importantly, I could get attorney's fees if I win. So I think all those strongest components are in this bill.
And just a little bit more on the attorney's fees provision, which is incredibly important, and everyone here says that any, legitimate anti-SLAPP bill will have a strong attorney's fees provision. There are also fees that can be assessed if the defendant frivolously files an anti-SLAPP motion, that they're basically just trying to, delay what would otherwise be a case with merit from moving forward. So it's not just everything in the defendant's favor here. The plaintiff, if they can show that, the defendant just frivolously filed this motion, can also receive attorney's fees on their behalf. Under this scenario, which I think it's important to show that it's really the bill and any good anti-SLAPP legislation, in particular the Speak Free Act, strikes that balance, and that's important.
Let me give you a concrete example. Actually, let me give you a hypothetical example. Let's imagine that you are reporting on a real estate tycoon, and you estimate that his personal worth is maybe $2 or $3 or $4 billion instead of maybe $10 billion. The issue about whether that's defamatory can be resolved really, really quickly in an early proceeding under the law here. This is just a hypothetical example pulled out of the air.
Great. So what I want to do now is talk about some of the, some of the objections that are raised sometimes about anti-SLAPP legislation in general or federal legislation. Some of these, let me just open up the panel first in terms of what you hear, especially Evan, obviously working on the advocacy side of this, you probably hear objections more than anyone else about when you tell people about this. What are the common objections you hear, and how do you respond?
Yeah, just following what's already been said, to make sure this doesn't deter parties from filing legitimate lawsuits. And as Laurent mentioned, there's a mechanism in the bill that prevents people from doing that by, if the court finds that the anti-SLAPP motion was frivolous or solely intended to cause unnecessarily delay, then the court will award attorney's fees to the other side. And just as a lawyer practically working on these issues in California, I think most plaintiffs' attorneys there understand that if you have a legitimate defamation lawsuit, you don't have to worry about the anti-SLAPP law. And then some of the other objections we've heard haven't really been based on facts. They're just sort of like hypothetical things there. I'm happy to address any specific concerns, but most of the ones we see are just sort of throwing out potential examples that really aren't based, don't have any merit.
Yeah, you get this strange thing of people saying it's going to deny someone access to justice, right? And they put up this roadblock to justice. And it's just ludicrous, right? It ignores the fact that everyone nearly who gets hit by one of these lawsuits right now has no access to justice because they can't afford it. All of you right now, if you got hit by one of these lawsuits, by a SLAPP suit, I can with bare certainty say that you would not want to put up your personal money to fight it. You don't have access to justice. And so to make the claim that by leveling the playing field we're denying access to justice, I would say is patently false.
And, there are some folks out there who they try to take this bill and anti-SLAPP legislation and sort of pull it like way beyond the scope. They talk about it being like the proverbial camel's nose under the tent for tort reform. And then that immediately sort of makes a certain segment of politically active people sort of box in and say, we can't support that because that's just going to lead to all of these other things that we can't support. But at the end of the day, they still, when you ask them about this legislation in particular, and about anti-SLAPP legislation in particular, they generally are supportive of it. I was on a panel, and I think, Kevin, you were there with me, was it a year ago maybe, where we had someone from the AAJ who said, yeah, we generally support anti-SLAPP legislation. We just don't necessarily support the fee shifting component that's in it.
Just because of the whole point of the bill.
Right, right, but at the same time, even those who are in opposition to the legislation fundamentally still understand and approve of the merits of it. It's just one particular component of it that they can't stomach because of other political reasons.
Yeah, I think an ideal anti-SLAPP laws actually create opportunities for people who do, for whatever reason, make a living going to trial. I mean, actually, it turns out to create the possibility for some trial attorneys actually to recover in context or to be engaged in cases they otherwise couldn't afford to be engaged. So that's a real thing. And so rather than sort of identify this as a tort reform issue, this is really a fundamental rights issue. And then I'll add to that nothing prevents, nothing prevents states from doing stuff above the floor of protection that federal anti-SLAPP legislation could provide. I mean, there may be some constitutional limits on what states can do, but states can be inventive. And we found in the context of libel law and some other First Amendment contexts that the different states will look at what the federal law says based on Supreme Court decisions, but maybe they'll provide even more protection than the federal system provides. So that can happen too.
Well, I'm using some of the notes from that panel we did last year. And one of the things I remember I researched, which I think came out of something maybe that Mark Goldwitz from the PPP and the California Anti-SLAPP had pulled together, was some numbers regarding the use of anti-SLAPP motions in California, which does have one of the strongest laws in the country. And they had found that between the fiscal years of 2005 and 2009, given over 6 million civil filings in California courts, the anti-SLAPP motion was only introduced less than 3,000 times, which is about 0.05% of the total civil filings. So it's clearly not a barrier to lawsuits being filed. I mean, it's, you're talking about still 6 million civil filings. You're talking about an anti-SLAPP motion to dismiss being used just a completely minuscule amount of time. And this is one of the strongest laws in the country. What it tells me is it's being used when it needs to be used.
Yeah, and just to piggyback on that, I think that's really important to address this concern that it's going to clog the federal courts with this new motion, right? When you're looking at less than 1%, the facts just don't back that up. And I think that number is significant because it shows that SLAPPs are enough of a problem that they need to be addressed, but the number is small enough to show that it's not going to clog the courts in any way.
Great. So the last question I have for the panel, and I want to open it up to any audience questions, is just talking about kind of moving forward. How do you see the politics playing out of both the federal legislation and what's been going on with the states? How do you see maybe the next, say, 12 to 18 months movement on at both levels, state or federal?
So we've been at,
You guys are the political.
yeah.
Yeah, I'll start it off. I think that you've heard a little bit of unanimity on this panel from folks who are supportive of Congressman Rivera and Golden Neshew's legislation, Speak Free Act. We are excited and hopeful that it's going to have a hearing next month, knock on wood, I believe, or I hope in the House of Representatives. I'm not going to say, like, I'm just sort of from the tea leaves and the stirrings that I've been hearing, I'm hoping that to be the case. And hopefully the momentum that comes out of that hearing will carry over through a markup and getting it out of the House. And then we can deal with the folks over on the Senate side, where we also think that there is excitement for the issue and the legislation. And in particular, I think, we've sort of made jokes either indirectly or directly about Trump and others. And, in particular, he's made statements about wanting to roll back libel laws, make it easier to sue reporters, to sue other people in general. And what's been the only good aspect that's really come out of that in that conversation that he's having, or that he's put out there, is that it's made people focus even more so on looking at this issue and similar issues, and the fact that there is a need for protections at the federal level to ensure that what he's talking about does not happen. Because I think whether you're a reporter or you're someone who just likes to write and share your opinions and express yourself on the internet, what he's saying is scary. And so, looking at that, I think that we're actually coming into this situation now where there's a lot of political energy for actually trying to move this bill and related legislation that will help to empower and protect individuals in the speech that they make online.
Yeah, I mean, I have to say this is like the most hopeful and optimistic I've been. I think Kevin can attest this. 6 years ago, I think we were one of the only organizations really pushing for this, and we had a bill from Congressman Cohen in the House. It was a partisan bill by Democrats that didn't go anywhere. A few years later, we had Senator Kyle, a Republican in the Senate, introduce a bill, federal anti-SLAPP bill. It didn't go anywhere, and so this is the first time we've seen a bipartisan federal anti-SLAPP bill. Now it has over 30 co-sponsors. A lot of energy behind it. All of these great groups are now, really pushing for it. So, I mean, I think we're in the best place we've ever been.
And these things take time, but you all might reflect on the last time anything moved quickly in Congress, and this thing is moving at lightning speed compared to just about everything else out there. This is a conversation that, as many people on this panel have mentioned, was very niche even just a year ago, and now it's really been blown into the open. It's a conversation that we're having with offices, many off the Judiciary Committee, who aren't necessarily focused on legal reforms day to day, but they recognize that this is very important for their constituents. So I'm very hopeful that we can move something forward in a quick, as far as quick things move around here manner.
And I think
that comes from someone that worked in the House for a long time, so no hard feelings.
Yeah, and I think, just looking at the optics and of everything that's going on with this legislation and just the climate that we're in, and even, the subject matter of this hearing, why policymakers should protect public speech online, that's not going to disappear. After this Congress, it's not going to become a moot issue. It's still going to be out there. People are going to continue to only increase, in their usage of the internet, and whether it's for, their own speech purposes or for analyzing and reading other individuals' speech in order to make decisions. And so hopefully we can, through the Barenthal issue legislation moving forward, deal with a big chunk of this issue. But I think the reality is that, this is the new environment that we live in, where people use and depend upon, whether it's online reviews or online statements, whether it's Facebook, Twitter, obviously Yelp on my end, and all the other platforms that are out there in order to have our interactions. And so I think that it's the issue of our generation, I almost want to say.
Yeah, I think, I've been lucky enough to be able to work on internet issues for, more than 25 years now. But at the heart of it has always been this idea of individual empowerment, and it turns out that is a bipartisan value. It is easy for you to talk to your bosses. You're not protecting an industry in your district. You're not picking one side in a fight. You are protecting voters. We like protecting voters, and regardless of your party affiliation, regardless of your district, the fact that you can go tell your district and tell your voters that you have done something to protect a value that we have now increasingly grown to expect in our interactions on the internet. That's a good thing. That's a good message to be able to share.
I think that the message in this political climate and everything we've talked about, you've heard a lot of stuff is important. And I think the one thing I take away from it is the time for this bill is now. It's time to make the First Amendment great again. I couldn't resist, sorry.
Good tagline for the bill. Great. Well, I want to open it up. I know we've covered a lot of issues. I know there's a kind of a variety of people in the room with experience on this. So there's, you can ask technical questions. You can ask, kind of high-level questions too. One of the goals of putting this panel together was to provide really experts for anyone that had questions about just how SLAPPs or anti-SLAPP legislation works, and we wanted to make them available. So, any questions?
I was just joking that I'm probably about to get sued for trademark infringement for that last line, which of course would be a slap. So please pass this law.
Yeah, Kevin, you're fired, which is also trademark infringement, because I think he also got that trademark.
He did get a trademark.
That's right,
yes.
So you're fired.
Great. Well, if there's no other questions, we'll go ahead and just end it there. Please join me in thanking our panelists and our representative.
Thank you.